when emergency medicine becomes something else, or how medical countermeasures, public health emergencies, and the erosion of informed consent fit together. Hello, I am Dr. K. Paul Stoller asking what happens when a public health emergency sticks around for years, when products are labeled countermeasures and broad government immunity kicks in, when informed consent, once a bedrock of medicine, starts to vanish. In this video, I unpack how emergency law, regulatory carve-outs, and medical deployments merge into something very different than what most believe. In the United States, the Public Readiness and Emergency Preparedness Act, PrEP Act, allows for broad immunity for covered persons during a declared emergency. The law defines a narrow exception only for willful misconduct, disregard of a known or obvious risk. That means once an emergency is declared, certain products, called medical countermeasures, MCMs, can be deployed with fewer safeguards than is normally the case in medicine. Meanwhile, the Food and Drug Administration's emergency use authorization framework remains active. Together, these legal regimes create a system where consent and standard consumer protections are significantly altered. When a public health emergency is proclaimed, the rules shift. Products can be authorized under less tested conditions. Recipients might receive fact sheets, but the legal liability for manufacturers, distributors, and government actors is heavily limited. Under EUA and PrEP law, labels such as investigational and standard of care shift meaning, and sometimes the rights to refuse or to full disclosure become murkier. And when an emergency status is extended over years, the temporary becomes semi-permanent. In conventional clinical care, informed consent means you are told of known risks and benefits. You decide. In the emergency countermeasure world, however, disclosure requirements may be weaker or less enforced. Recipients may face coercion, employment demands, education access, even if officially voluntary. Legal immunity reduces the recourse for harms and shifts burdens onto individuals to prove willful misconduct. When medical intervention becomes a state-deployed countermeasure, and not just care, we enter a fundamentally different paradigm. If consent, transparency, and liability are weakened, trust in public health institutions erodes. When individuals feel they've been pressured or misled, the social contract weakens. And when emergency powers become routine, the extraordinary becomes the everyday. And with that, the checks and balances of oversight begin to fade. There are paths forward. Clarify at the state level to ensure that during emergencies, recipients receive full, explicit fact sheets about legal status, rights, risks, and benefits. File lawsuits as required to compel agencies to act or be held accountable, though that path is uphill. Advocate for structural reform. Repeal or amend laws like the PrEP Act. Strengthen transparency. Restore full medical ethics oversight. Raise public awareness. Make the emergency paradigm visible, not invisible. Build friction into the system so countermeasures remain subject to scrutiny. Medicine and public health are about care, trust, and partnership. When the legal regime recasts them as tools of national deployment, we risk losing the foundation of that partnership. If we want informed consent to mean more than a box to tick, if we want public health institutions to be trusted instead of feared, we must illuminate the emergency machinery and begin dismantling those structural carve-outs. Because no emergency should suspend the human right to refuse what is unwanted. Yes, I am aware COVID was a democide meant to cull humanity. But let's make sure the misuse and abuse of power doesn't happen again. That is the first priority. Yes, there needs to be accountability for what happened, but first let's make sure it won't be so easy to pull off another democide again. Thank you for watching.